Okay, we are going live now. Michael, how are you today?
I'm doing good, Scott. How are you?
I am doing fantastic. Okay, so we've got a few people, actually quite a few people who are logging in to the program today. Um, my name is Scott Fuller. I'm the founder of leavingthebayarea.com and leavingsocal.com. And as the names suggest, we do relocation. We help people relocate out of major metropolitan areas in California. In a lot of cases, we help people move out of state as well. I think for the purposes of this webinar, we're going to be talking more about landlord. If you're a landlord and let's say you're looking to maybe move or diversify your portfolio outside of San Francisco or out of California, but you have tenants and you're not quite sure how to do that, that's a few of the topics that we're going to be talking about today. Also, we have to preface by saying that Michael is an attorney, however, and he's going to be giving us a lot of great information today on the topic matter, but we have to understand that this shouldn't be necessarily construed as legal advice. And if you have specific questions regarding your scenario, you should contact somebody like Michael to get that specific legal advice. So Michael McLaughlin is a founding partner of McLaughlin Sanchez LLP, concentrates on his practice on representing landlords and handling tenant disputes. So Michael, welcome again. Appreciate you coming on today.
Thanks, Scott. Glad to be here.
Give us a little background. Tell us about Mike McLaughlin, what you do and what you personally and professionally.
Yeah, well, personally, I actually grew up in, don't hold this against me, but I grew up in the Seattle area. So I'm not a native of Seattle. I was actually born in the District of Columbia back in the 60s. And then I grew up in Seattle when I was from 2 years old until whenever. So I'm a rabid Seahawks fan. And I hope nobody keeps that, holds that against me.
That's okay. We're fine.
The early part of my career, I was actually a senior congressional staffer. So I worked on Capitol Hill for a couple members of Congress in the very early 90s, the very first Bush administration, so Poppy Bush through Bill Clinton's first term. And then I went to law school. And then I moved back to Washington. And subsequently after that, I moved to New York. So I've been practicing law here for about 22 years.
Okay.
I moved to San Francisco about 10 years ago. And a real passion of mine is real property law. I just enjoy it. I loved it in law school. And I just love the issues that come up in landlord tenant. In the Bay Area and in other jurisdictions in California and Southern California as well, we have really rigorous rent control and eviction protection statutes. And it's really just a lawyer's bonanza. I tell people frequently, I mean it, that you really can't successfully get possession of real property back if you have a tenant in possession without the assistance of a lawyer in California. The system is actually designed for the person representing themselves trying to do that to fail. Mm-hmm. And so it really is a boon practice here in the Bay Area. We've got a law firm of about 10 people and we serve landlords only.
And I'm sure you guys are extremely busy, right?
Yeah, especially this year. This year has been a mix of, frustrations and being overwhelmed by people looking for help, answers to basic questions.
Well, let's go through some of those basic questions. And speaking of questions, I know that we're going to have participants on here who will have questions for us. Now, we're going to try to cover a lot of content in a short period of time. We'll try to keep this to about 45 minutes, just so you who are watching can, kind of plan ahead. If you do have questions, there is a Q&A box on here, assuming that you are logged in and not dialed in. But feel free to type in your question. We'll make sure Michael answers it. We'll get everything out that, that we need to. But Michael, here's where I'd kind of like to start. So we're getting a lot of inquiries from property owners who are saying, Scott, I'm looking to sell my property, whether it's, a duplex or whether it's a larger multifamily property.
Right.
They want to reallocate that money, do a 1031 exchange, whatever that looks like, to somewhere else. However, the challenge is that they have a lease. And so they'll say, well, Scott, I've got a month-to-month lease and I can just give them 30 days and they're out and then we can go ahead and move forward with, acquiring a different property and getting this property sold. However, it's not that simple. Is that right?
That is right.
Okay.
And I have thoughts on this. Definitely. Do you want me to launch into?
I want you to go. Let's go. Let's roll.
Let's go with it. Okay. So Scott, I should have said in my introduction, I was raised by a lawyer. So I feel like I've been practicing law since the time I was about 6 years old. And I mean that in a way, when I work with clients, I like clients to understand not just the nuts and bolts, but I'd like people to understand the universe that we're dealing with. And one of the best strategies, particularly now in this COVID era and wanting to get a tenant out, whether they're under a lease and all that kind of stuff, is you need to understand that when a tenant is in possession of real property, they have an interest in that property. They have a real valuable interest. Now, very often I get people to come to me and say, but I have the deed, I have title. And I say to them, yes, there are really three principal attributes of real property. There's title, there's alienability, and then there's the right to possession. When you want a tenant to leave, you need to figure out how to get that right to possession back from the tenant. In the rent control jurisdictions in the Bay Area, particularly Oakland, Berkeley, and San Francisco, where you have to have a just cause to terminate that tenancy. You can't just serve them with a 30 or a 60-day notice. You actually have to state in that notice the reason, the justification for terminating that tenancy. And wanting to move on from this property and sell it vacant to maximize the value, because the buyers will pay more for a vacant property than they will one with a tenant. One of the best options for getting the tenant out is to negotiate with them. But you need to go into the negotiation realizing what you're doing, right? It's a cash for keys or a buyout, where you go in and you basically say to the tenant, I would like you to leave and I want to talk with you about what that looks like. Just realize that you're actually trying to purchase from them, particularly in the rent control jurisdiction where you have to prove a just cause. You're trying to buy back from them an interest that they have in your property. When you entered into the lease initially, you voluntarily, by contract, gave them not only contractual rights, but an estate in property, right? They have an estate in your land, and you're trying to buy them back. And I deal very frequently with people who are incensed that they have to pay a tenant to leave when they hold property, when they hold title.
Sure.
And I think it's really important that people realize, particularly in the rent control jurisdictions where you have to prove a just cause, that yes, they don't have title, but you need to purchase that back from them. And so then the question becomes, how valuable is that? How do you value that interest? Well, first place to look is, do you have a justification for getting them out of possession? Sometimes you do. For example, if you're not looking to sell, but you want to move into the property and you can do an owner move-in eviction, you can look at what the statutory amount is for relocation monies. And that's a good guide of what they would be entitled to if you serve them with a proper eviction notice, right? But you may be willing to give them a premium above that to avoid the complications, time, delay, and costs of doing an eviction action. When you don't have a just cause, when you can't state a cause, the tenant then is going to have maximum leverage in that negotiation. They can say, I'm not interested in leaving, or yes, but I'll leave for $120,000, right? And then in that situation, you need to ask yourself, how much more valuable is this property vacant than it is with the tenant? If it's $250,000 more valuable on the open market vacant, you might be willing to give a tenant $50,000 or $60,000. You're still going to be ahead in the game, and the tenant might get what they're interested in to move along. So doing a buyout, really good idea. Really good way to think about things, particularly now with the courts dealing with COVID and trials and so forth.
What are some other examples? We talked about just cause. So we talked about one, which may or may not be just cause, but that's the idea of, I want to be able to sell vacant to be able to purchase somewhere else. Second one we talked about was, I'd like to move in. What are some other examples of just cause that you see?
Yeah, so let me explain. That's a great question. Let me run down basically how all the rent control and eviction protection statutes in the state of California operate kind of the same way. And I can tell you, I'm going to be really brief on this, but by the time I'm finished, you will understand rent control and eviction protection. All of these statutes, including the statewide statute, AB 1482, and the local rent control statutes in the rent control jurisdictions like San Francisco, Berkeley, and Oakland, they all have a statute that has two principal components. The first is what I call price controls, the rent controls. And that says to the landlord, This is the amount of rent that you can raise every year. You're limited by whatever the statute says. In San Francisco, for example, it's 60% of the consumer price index per year. Under state law, it is 5% plus the local consumer price index, the local rate of inflation. So there are price controls. Not super interesting, but it's important to know that that's a feature of these statutes. The second part is the requirement that you prove a just cause to evict, right? You got to state that just cause in the notice. There are two principal categories of those. There are the for cause and the not for cause justifications, just causes. Let's talk really briefly about the for cause. That would be, for example, failure to pay the rent, breaching the lease, creating a nuisance. Those are three of the biggest for cause. And in that, I mean, the tenant has done something affirmatively wrong, and that gives the landlord the justification to get possession back, terminate that tenancy. The second category is not for cause. And that is where the tenant didn't do anything wrong, and yet the law allows the owner to nevertheless recover possession. The big ones there are owner move-ins, evictions. Tenant didn't do anything wrong, but the law allows the owner to move back in. An Ellis Act eviction, where you're just going to take the entire property off the rental market. And the third is that you have to do some sort of substantial rehabilitation to the property. There's repairs that need to be made, and it's not safe for the tenant to be in possession. You will notice, though, that not within any of those causes, either the for cause or the no fault evictions, is I want to sell the property vacant. That, unfortunately, is not a justification under any of the rent control statutes.
Got it. Okay. So I might be jumping ahead on this. We're talking about for cause and not for cause. Within the COVID environment right now, with a lot of tenants who may not have the ability to pay, and let's say the owner does, and again, I'm very, very much jumping ahead. Where does that fall into, for cause or not for cause, if the tenant is not making payments and the protections from the state right now?
Great question. Excellent question. And this is true whether you're under the state law or whether you're under the local. Let's talk briefly about what that means. Let's say the tenant is not paying the rent and they've been laid off, and so they have a reason for not paying the rent. Okay. That is, non-payment of rent is still a just cause, but the tenant might have what we lawyers call an affirmative defense to the unlawful detainer action. It's a mouthful. It means if you serve me with a notice terminating my tenant because I didn't pay the rent, I have a defense to that. I can defeat your eviction action by raising this defense. Mm-hmm. And so how is that working right now? Scott, you and I were talking earlier that the law in this area right now is incredibly difficult to understand. It is overlapping. It is, in the 22 years that I've been practicing law, this is the first time where I have to scratch my head and say, okay, what are we dealing with in any particular situation? And the reason for that is we have the state law, we have the state passed AB 3088, and we'll talk more about that, the Tenant Protection Acts that the legislature passed a couple of months ago. Then we have local county ordinances, like the County of Alameda has passed an ordinance, a tenant protection ordinance. And then we have city ordinances. So for example, the city of Oakland has passed an eviction moratorium statute. And so we've got three layers of law that we have to deal with. And very frequently I have people come to me and say, hey, I heard that the tenants have to pay 25% and I can get them out if they don't. And what they're talking about is that's a feature of the state passed statute, right? Okay. For rent that became due on September 1st and going forward, if you serve a notice, and it's no longer a 3-day notice for non-payment of rent right now, it's now a 15-day notice, okay? The tenant can assert a defense to that notice by saying essentially, I lost my job, I can't afford to pay. For the time period now, from September 1st through the end of February, they need to pay 25%, and then they can stop that eviction even though they're not paying you the full 100% of the rent. That's the state statute. In Oakland, for example, you can't serve this notice at all because the Oakland statute gives an absolute defense to any notice terminating tenancy for non-payment of rent right now, okay? So if you're listening to this program and you have a non-payment of rent tenant, you want to move forward on it, my number one advice is go talk to a lawyer. You need to go talk to a lawyer who practices in this area. And we'll drill down with you about the particulars. You know, did you serve notices that were required by the statute for rent that accrued prior to September 1st? And then what do we do about rent that accrued September 1st and going forward? Because the rules are a little bit different.
And it seems like these are continuing to change, right? I mean, like you said, it's become so dynamic that, you know, it's something that applies today may not apply, you know, in a couple of months.
That's right. So here's a real world example that I'm having. One of the top counsels in my firm and I practice law in much the same way. And we're scratching our heads saying, is this amendment to the rent ordinance that San Francisco passed effective right now? And what that amendment said was, other than for non-payment of rent cases and other than for Ellis Act evictions, there are no evictions that can go forward in the city of San Francisco until early in next year, until the end of February. Well, was that statute passed in violation of the prohibition on making changes in AB 3088? Well, I don't know. We haven't litigated that case yet, but it's a big risk. You know, we think it's invalid because it was passed after August 19th. The city thinks it's valid because they gave a carve out for non-payment of rent. And they think that 3088 only prevents them from dealing with or legislating on the non-payment of rent case. So it's incredibly confusing right now about just what the law is.
Yeah, it's a mess. I mean, right?
It is a mess. To be honest with you, I've just been crying out for a uniformity. And I think 3088 tried to do that, but didn't across the board preempt local law, right? So it left some things in place that were passed before certain dates and so forth.
I've got a question for you, Michael. So let's say that if I own property and I have a tenant who's not paying rent, is it better for me to contact the tenant directly, whether that's through verbal communication to try to work something out or to serve some type of notice, or am I better off and more protected if I contact an attorney before I make any contact with the tenant?
Great question. Excellent question. The answer is talk to an attorney before you do anything.
Okay.
Because the answer about whether we should serve a notice now, send a communication, or hold our fire depends on the jurisdiction. Let me give you a real world example. Just yesterday afternoon, client called me. Tenant is not paying the rent, right? Okay. Properties in Berkeley. Berkeley right now has an absolute prohibition on moving forward with any type of eviction other than for public health and safety. And so reaching out now, and he said, well, I want to send them a note, just giving them an update on their balance. And my answer is, what, let me ask you something. What good is going to be served by that? What are we trying to accomplish by serving that notice right now?
Sure. We
can't do anything about it. It's not a prerequisite. When the time comes early next winter and that we can serve a notice for non-payment, subject to their defenses, we don't need to have served this. And so, and by the way, this is a litigious, difficult tenant situation where the landlord and tenant have not gotten along for years, and they make complaints and they make life miserable. I said, so you're going to want to send this balance statement to them that will just inflame them. And their response is going to be to make your life miserable this winter, to complain about literally everything. The doors squeak, the dishwasher doesn't work, everything. They're going to run the traps on you. And so the wisest counsel there is just hold your fire. When we're able to serve a notice, you not having sent this statement will not act as a waiver of your rights to proceed to evict them for non-payment of rent.
Okay. And I would have to imagine, I mean, that there's a lot of public resources out there available to tenants because California favors tenants, generally speaking. And so you have to, I think, as a landlord, you have to expect that the tenants are doing the due diligence on their own to find out what their rights are. Now, they may not be contacting an attorney per se, but I think there's a lot of public resources available for them to get a lot of these questions answered, to find out if their landlord is handling things incorrectly. And that's a huge liability to the landlord to make a mistake, right? In some sort of communication or notice that they're giving.
It is. Let me say a couple of things on that. Yes, that's absolutely true. It is an exceptionally rare situation where I have a tenant who's not represented by, for example, in San Francisco, the Eviction Defense Collaborative, the nonprofit that is set up and allows, it's essentially like a public defender in the criminal law, right? The tenant gets the representation of the lawyer, but doesn't have to pay a fee for it. It's a service that's available for tenants. Landlords don't get that. There are no nonprofit groups set up to represent landlords free of charge. So in other words, you'll end up paying for your lawyer, but the tenant will not have to pay for theirs.
Sure.
Now, one of the other things too, Scott, that is a really important feature of particularly the local rent control statutes is the concept of tenant harassment, okay? And tenants run the gamut of what they consider harassment. You sending them a notice, a statement during the middle of COVID, when you knew or should have known that there's nothing you can do about it, could be construed as tenant harassment. You got to be really, really careful of that, because under the local rent control statutes, the damages for that kind of thing are attorney's fees and triple damages that the tenant can prove.
Wow.
So super important not to do that. This is why you want to be guided by a competent attorney in this area. Mm-hmm. One last point I always take an opportunity to do this is when you have rental property, you want to make sure that you're adequately insured. And second, with respect to your insurance, you want to make sure that you understand the coverage. So I'm going to talk very briefly about this, but I always give a plug to
no, this is great.
Yeah, because I have clients who come to me and they're not covered by insurance, or they don't have the right insurance in place, and it's a total disaster. So the first thing I always tell people is make sure that you're insured and that your insurance broker or whoever's writing your insurance policy, your State Farm, Farmers, whoever it is, that they understand that this is not an owner-occupied property, that this is a tenant-occupied property, because they'll write an insurance policy, a landlord policy, and that landlord policy comes with a number of features. One is protection against wrongful eviction. Okay. But with respect to that, the insurers, the insurance companies are making substantial changes lately to what their coverage allows. So as we just talked a minute ago, there is triple damages plus attorney's fees for tenant harassment. That same concept exists under the local rent control statutes for wrongful eviction. So if you wrongfully evict someone, you're going to end up with triple damages plus attorney's fees. The insurance policies are being written tighter because the insurance companies are tired of paying out on these claims. So they may not cover you for the tripling of damages, and they may exclude attorney's fees. So when you get your insurance policy, it's not okay to just say, I have wrongful eviction insurance, I'm great.
Yeah.
You need to understand what it is that you're covered for.
That's a great point. And I think when most property owners are thinking about insurance, they're just thinking about property damage or that type of a liability. It's not necessarily contractual liability or what you're talking about here. So they should contact their insurance broker and find out, hey, what am I actually covered for, within those confines, right?
Yeah, taking a few minutes when you're going to get your insurance policy to really understand what you're covered for is critical, because you don't want to learn what your coverage includes but doesn't exclude and excludes when we're sitting in the mediation room and you've been sued for habitability claims or wrongful eviction or both, and the the insurance rep at the end of the table who's in the same room with you, right? But is not your friend. He is trying to find every single way to move a bulk of the money that needs to be paid in settlement over to you personally to save the insurance company. And that's the worst time possible to figure out, what am I covered for?
That's a great point. Yeah.
Does it exclude attorney's fees? It might. A lot of the policies that are being written now do.
So I want to remind everybody, we have a question here, and I want to remind our viewers that are on live, if you have any questions, feel free to type it into the Q&A box or into the chat box, and we will answer those live for you. So the question here, Michael, is there a way to structure a lease to give you a benefit to increase your chances of getting the tenant out if or when you need to sell? So we're talking about the very beginning when you're structuring a brand new tenant lease.
Yeah, this is an excellent, excellent question. And the answer depends on whether you're subject to a local statute like San Francisco, Oakland, and Berkeley. The local statutes there. Let's talk about that for a minute, and then we're going to talk about statewide. Under the local ordinances, San Francisco, Oakland, Berkeley, there's nothing that you can put into the lease that will carve out for you not having to comply with the just cause to evict provisions, having to state a just cause to terminate that tenancy. No matter what you do, and I jokingly tell people this: you and the tenant can both agree and write an addendum, and you can get Pope Francis to come and bless it, and it still doesn't matter. It doesn't matter that you both agreed to it. It doesn't matter that the lease says it's only good for 6 months and then you got to leave, and that you wrote an addendum that says that the tenant agrees that they will leave on that date 6 months from now. It's against public policy for a tenant to waive their rights under the rent ordinance. And so the attempt to carve yourself out of the just cause to evict provisions is void as a matter of public policy, not enforceable.
Yeah.
Under state law, if you have a property that's not subject to the just cause to evict provisions of the statute, and let me talk a few of these. I don't want to digress too deeply into the weeds, but one of the first things we lawyers do is we ask ourselves, is this property subject to the just cause to evict provisions? Because not every property is, right? In San Francisco now, they have extended out the applicability of the just cause to evict provisions of the ordinance to all residential real property in the city, no matter when it was built. It used to be that it only applied to those properties that were built before June 13th, 1979. But about a year ago, they extended that out. Now everybody's subject to it in San Francisco, all residential real property, subject to just cause to evict. Under the state statute, you might not be subject to the just cause to evict provisions that exist statewide. So let's take an example, just in property in Contra Costa County, for example. No local just cause to evict statute, but you might be subject to the statewide statute that was passed about a year ago. It's beyond the scope of this call, and I would recommend that if anybody has that kind of situation, you talk to a practitioner, a lawyer who practices in the area, to find out whether you're subject to it. But the question is there something I can do to structure a lease? And the answer is yes. If you look in the statute, AB 1482, and take, for example, a single family home or a condominium, property whose title is separately alienable to the title to any other property. If you state in the lease that the property is not subject to the just cause to evict provisions, then that kind of property will be exempt. For properties leases that were entered into prior to July 1st, 2020, you have to give notice to the tenant of that. For leases that were entered into after July 1st, it needs to be in the lease. So what does that mean? Well, if you entered into a 1-year lease in August 1st of this year and you did not include this disclaimer in there, you're going to have to wait until the end of the term. And then the lease will go month to month, and then we can serve a certain notice changing the terms of tenancy that goes into effect after that. So eventually you'll be exempted out if you didn't include this provision in your lease. at the outset. So again, when you're entering into a lease at the outset, the most important thing that I can recommend to people is to get competent legal advice. Go spend $500 and buy an hour of time to somebody who practices in this area and figure out what your lease needs to do. The biggest disasters, and the reason why I have such a booming practice, is people just go onto Google, they pull a lease off and they sign it with the tenant and have no idea what they're doing. And then the situation comes up down the road and they say, oh, gee, I need to get out of this. And then they come and see me. And I'm like, well, you know, there's nothing I can do about this now. And what I see is just a lot of penny wise and pound foolish. You know, that people don't want to spend an hour of time with a lawyer. They just go into Google, they print off whatever, they sign stuff, they don't have any idea what they're doing. And then it becomes very difficult to navigate out.
And I think you've got a lot of property owners who have had a lot of experience in owning property and being landlords over the years, right? But the reality is that leases that you were drafting up, you know, 10, 20 years ago, and the laws that surround them are going to be completely different than what you're looking at today. So you can't base it off of your previous experience. You have to understand what are the implications that we're looking at in these general, you know, areas that we've talked about, but also through COVID and a lot of the new laws that continue to come in and change. I mean, look, Michael, you do this full time. And you told me before that it's challenging to continue to keep up with everything. How could an individual landlord who's doing this part-time, you know, most of them have the capacity to be able to find the time to do this? It's just very difficult. You've got to spend the money to do it the right way. So you're not, you know, you're not trying to, you know, tread water later on down the road.
Yeah, your comment there just segues into another point that I want to conclude on our last thing about entering into leases. Two things. One, for somebody who is landlording in California, you should, it is my strongest recommendation, to belong to one of the local property owner associations. And there are a number of them in the Bay Area. The biggest one in San Francisco is the San Francisco Apartment Association. There's also the Small Property Owners Association. But the SFAA is really the biggest one in San Francisco. What does that give you? A couple things. One is their amazing educational programs. They put on hour-long lectures on all kinds of topics, and they have really seasoned landlord professionals that do those classes. They're enormously valuable. You're going to get so much value out of that it makes the $250 or whatever it is annual fee for belonging worth it. And there's a reason why it's such a successful organization. If you go to their monthly meeting, there's probably 200 people in attendance. It's well attended because the programs are really good.
Yeah.
Secondly, and this is the most important point, is that most of these organizations like SFAA, like the East Bay Rental Housing Association, EBRA, they have a form lease. That lease is tailored for that individual rent control jurisdiction. It will have, and it will cover the waterfront. They're well lawyered. And so what the additional benefit is, if you're going to be one of those persons who hears that you should consult a lawyer, but you don't want to do that, notwithstanding the advice to do that, at least use the form lease from the associations, because 90% of the time you're going to get it right, because it's hard to fail on those form leases from the associations. They're designed to protect you. Now, what happens is, like, for example, of trying to check the box that says the property is not subject to rent control, is that you may be checking boxes without understanding whether or not you're exempt. So it's still opportunities to make mistakes if you don't get legal advice before you enter into the lease. But at least with a form lease, California Association of Realtors outside of the rent control jurisdictions, the local landlord groups inside the rent control jurisdictions, at least it gives you a better than 50-50 shot of getting it right if you use those associations' leases.
That's a great call. And also, I mean, a lot of great speakers, a lot of great information, networking, and it can help you to become a more astute investor, right? Belonging to those types of organizations.
That's right.
Yeah. Michael, another question here. So we know through COVID, there's been, as we talked about, a lot of non-payment from tenants and forbearance and everything else, you know, that's kind of happening here. What are the options if I'm a landlord and my tenant's not paying me, or they're paying me still a small portion, I'm still owed, I still have to pay my servicer, right? I still have to make my monthly mortgage payments. Is there any protections or laws that you're aware of that allows me to renegotiate on my behalf with my servicer if I need to, right? Now, again, we're talking about if I'm in a financial situation where I really need to renegotiate. What does that process look like, and is there success in doing that?
Well, let me say this, and just as a disclaimer, any lawyer has to let you know when they're outside of their wheelhouse, as it were. I have an excellent, if anybody's in a situation like this, I have an excellent lawyer who was an opponent of mine about 5 years ago on a case. And one of the best testimonials a lawyer can give another lawyer, that when he was your opponent before, you walked away from that engagement thinking, that's a great lawyer, I want to refer people to him. And I have in this area.
Perfect. Right? Okay. So we'll table that. Okay.
Yeah, but let me say this. There are some things out there, but there's not nearly enough for what people are facing. Like the real situation that I'm facing, Scott, is clients of mine who can't pay the mortgage because their tenant's not paying the rent. There's a lot of that going on. Mm-hmm. I'm not aware of any pool of money out, to like the PPP loan to give like a landlord in that situation money for that. There are some things that have been done both on the federal level and in AB 3088 that deal with regulating mortgage providers and mortgage lenders foreclosing. But it's a little out of my wheelhouse, but I'm not aware of anything that I can give you like the silver bullet and say, go do this and save yourself.
Pretty much talk to an attorney or talk to your servicer initially, just to let them know if there's a hardship or something like that from non-payment of rents, right?
Yeah.
Okay. Right. We talked about earlier about how to negotiate, when you're negotiating with a tenant to buy out their lease. We know now that has to be part of the process. And I know it's going to be, I'm going to ask you a question. You say, Scott, I can't really give you that answer. But what is an average dollar amount? Let's say if I have, a detached property with a single tenant, lease tenant or single lease on it.
Yep.
What can I expect to have to pay them to get them out of here? I mean, are we talking 1 month's worth of rent? Are we talking triple? Are we talking beyond that? Or, how do you go about determining what you're going to start to negotiate to try to get them out of the lease?
Great question. I have a lot of experience on this. Let me talk briefly also about this, another point that I want to make on buyout, since we're back on that topic. In the rent control jurisdictions, the local rent control jurisdictions, please do not start having a discussion with your tenant about buying them out without talking to a lawyer first. Okay. There are pre-negotiation disclosures and filings with the rent board that need to be made before you have that initial conversation, okay? And I can't unring the bell. So if you do that and then you come to me after you've already started the negotiations, you're already in violation of the statute and there's no cure for it. I can't cure that violation by subsequently giving you the pre-negotiation disclosure. So super important. Also, you are eventually going to need a lawyer anyway, because in order to comply with the buyout regulations and all the local statutes, it has to be drafted in such a way that the final paper agreement that you all sign has to comply with the ordinance anyway. And let me just say this, you'll fail if you try to do it on your own. You won't be able to do it. You need a lawyer. You won't be able to do it properly. So if you're looking to do that, my first and number one advice is see a lawyer before if the thought crosses your mind to buy someone out, that's a trigger to hire a lawyer first. Now, you asked the question of what's the average. I have to tell you, Scott, I have seen the full gamut of buyout amounts. Mm-hmm. A couple of points here. First, in the local rent control jurisdictions like San Francisco and Oakland, you have to file the final buyout agreement and they're publicly available. So if you want, you can actually go down to 25 Van Ness Street in San Francisco, go to Suite 320 and sit at one of their Tandy computers that go back to like 1983 and pull up all of the buyout agreements that have been filed in your neighborhood.
Interesting.
So you might be able,
okay.
Yeah, they're all publicly
I had no idea.
Yeah, they're publicly available. Now, what it doesn't say in most of these is what the circumstances were that led to that amount. But you can actually find out. You can do a non-scientific look-see survey on what other people in your neighborhood are paying. It's a great resource. If you have the time and inclination, it's great. I have paid as little as $0 for someone to leave, all the way up to $160,000. So let's talk about that. Sometimes you get into a buyout negotiation and the tenant is not represented and they really don't care to be there anymore, and they're great. They don't want you to pay them anything. They're okay if you just pay the moving expenses, and they'll move. Fantastic. That happens occasionally. Sometimes you end up having to pay hundreds of thousands of dollars for someone to leave because you don't have a just cause. You can never get rid of them. Let me give you a brief example of the one that I'm thinking of. Another lawyer served an improper notice, and then we had to start over again. But in the meantime, the tenant turned 60 and had been there since 1977. So they were a protected tenant in a multi-unit building. We could not evict them under any ground, unless we had just cause because they didn't pay the rent or was creating a nuisance. We couldn't do an owner move-in eviction. When it got to settling that dispute, we ended up having to pay $160,000. Now, the tenant because they had been there for literally over 40 years, they were paying about $1,800 a month in rent for an apartment that was at that time worth over $9,500. So you're going to be back in the black, even though you're paying $160,000 within about a year. The math worked out. So in that case, it was that. But really, as a practical matter, I generally see buyouts somewhere between $40,000 and $60,000. This is it's not uncommon for that. But I have had really sophisticated tenant lawyers on the other side come in and say, you don't have just cause. I want $95,000. And I just come back to them and say, listen, you know what? We're going to sell the property. A buyer is going to go and do an owner move-in eviction. So while we don't have a just cause, the buyer will settle it for $32,500.
And I would imagine, we're talking about the financial aspect of this, but I'm sure there's more of the emotional relationship aspect of it also. If you're self-managing and you've had a great relationship and rapport with these tenants, and you're trying to, just kind of have them help to understand why you're doing this, they might be a little bit more open to some of the terms that you're proposing, right?
That's right. Trying to negotiate with somebody that you have a poisonous relationship with.
And that's why you don't want to start the poison early on, right? You don't want to be combative. You want to be, just come from a sense of let's work together. Let's find, something that's a win-win for both of us, right?
Yeah, I have to be honest with you. Having a poisonous relationship, it happens. Sometimes it's unavoidable because it's not the landlord's issue. It just, every once in a while, you get a bad apple tenant. That's what I call the squeaky wheel, or a professional tenant. Right? Somebody who just has done this before. They've done it their whole life. They know exactly how to run the traps with you. Sometimes a bad relationship is unavoidable, but to the extent that you have control over it, almost zero good comes from getting crosswise with the tenant.
100%. 100%. So I just want to reiterate something that you said a few minutes ago, just because it's a very important point, but I want to make sure I understand it clearly. So if you're looking to approach somebody to buy out their lease in areas that there is, as you mentioned, that have the protection statutes, right? Rent control, things like that. You absolutely want to talk to an attorney first, because there's documents that need to be filed before you can even have that conversation. But what about in areas outside of the protected jurisdictions? Let's say we've got a property that's out in Stockton, no rent control. Should I still be contacting an attorney first before I approach the tenant for, we'll call it cash for keys?
Yeah, the answer is probably, because there are certain ways that we can structure it, the agreement, such that if they don't move out when they say they will in this voluntary contract, that would be grounds to go immediately to an eviction.
Okay.
So let me be really super clear. In the Stockton example, there's no local statute that requires a pre-negotiation disclosure. Without being glib, it really is the Wild West. So you can go in and you can just start talking to the tenant. You're not going to be violating any disclosure statute. But a little secret, there is a grounds for eviction if a tenant serves a written notice terminating tenancy, and that written notice is accepted in writing by the landlord, and the tenant thereafter doesn't leave when they said they would, you can go immediately to an unlawful detainer action in the non-rent control jurisdictions like that. We can, with the guidance of a lawyer, you can navigate that. But without a lawyer, you won't be aware of that little nugget right there. And we can help you structure your negotiations so that if they don't leave, you can actually move forward to get them out and enforce that agreement. Otherwise, you might be left with a breach of contract claim. For example, you might have paid them $15,000 up front with the balance coming. You paid them the $15,000. They didn't leave when they said they were. Now you have a breach of contract claim for the $15,000. But that doesn't thereafter, without proper structuring, give you a ground to terminate that tenancy.
Got it. Okay. So we're about 45 minutes in here. I want to remind all of our viewers right now, if there's anything that you want to be able to look at again, or if you know somebody who should watch this, because we've had a lot of great content and information today with Michael today. We will have copies of this recording available, I would say probably in about a week or so. And so you can always contact myself, Scott, S-C-O-T-T, at leavingthebayarea.com to request a copy of that. Michael, is there anything that we didn't cover that you think people need to absolutely know right now?
No, man, I think we did a pretty thorough job.
Agreed.
Yeah, it's pretty good. I will just say that, you know, I'm very open to dealing with landlords, and my law firm is McLaughlin Sanchez, LLP. It's msllp.law. It's Michael at msllp.law. If you have any questions, you want to just shoot me an email. I try to respond.
Michael at msllp.law.
.law.
Okay.
Right.
Look at you guys. You got the, you stepped up to the .law. I like that.
Yeah, we went .law. Somebody else had msllp.com.
That's great. Okay, Michael, hey, this has been fantastic. I mean, we've talked a lot, you know, over the years, and I'm glad that we got you on to, you know, talk about what you're seeing in the market right now. And I guess the, you know, the final thought for myself is this changes so quickly. The laws are changing so quickly. I think they're going to continue. You've got to contact an attorney such as Michael, or like Michael, that has the expertise to make sure you're represented properly when you're dealing with anything, you know, that has to do with landlord investment properties. So Michael, thanks again. Really appreciate it. Great information.
Yeah, Scott, thank you so much for the opportunity. I appreciate it. And thank everyone who was watching.
Okay. All right. You take care. Thanks, you guys.
Talk
okay.
soon.
Bye-bye.
Bye-bye.